Tully testified, and he explained the process by which the state police get involved. And one of the things that he said is that a contact number is given to the on-call person by a supervisor. So when Proctor was asked about how he got Lank's number, why didn't he say this? Why did he dance around that? So did Buchanan give him Lank's number? What was the number that Proctor had? And why didn't Proctor just answer the question, just say so? Tully testified that shortly after 7 a.m., he got a call from Buchanan. And he said normally he doesn't receive calls for that, but given who the victim was, Buchanan called to notify him. He testified that the state police have exclusive jurisdiction over unattended death investigations. Once again, we are hearing that state police got this call. The original call, according to Buchanan, was 6:44 a.m. Proctor gets a call at 6:48. Shortly after 7, Tully gets a call. But at the very beginning of the trial, Canton police said that the state declined. They weren't coming, or they made it sound that way in any event. And Tully said something very interesting. What he said makes sense, and it does sound like proper procedure. And this is what it was. State police get the call from the local police. And the local police are supposed to stand by and wait for guidance from state police in the meantime. So why wasn't that done then? Canton police abandoned the scene. Why was there no guidance given? And this guidance that is to be given, I'm assuming it would be done by the lead investigator at state police, and they call it a case officer. Well, that lead officer would be Proctor. So if Proctor is supposed to give them some sort of guidance, why didn't he? Why didn't he tell them, secure the scene, don't touch anything until we can get there? Did Proctor order a leaf blower? Gallagher didn't say that Proctor ordered him to do anything. The way Gallagher put it at the beginning of the trial was that there was blood on the snow, and he was concerned because the snow had really picked up and it was destroying the crime scene. He needed to figure out what to do with that. And he thought a tent would do no good because it was too windy. He testified they started to put up barrier tape, but it was windy. And so he had Good go get his leaf blower. And they did this makeshift evidence collection. And this is where we get into solo cups. Well, why then, if state police has exclusive jurisdiction, they've been notified at 6:44 a.m., Proctor knows about it by 6:48 a.m., state police has exclusive jurisdiction. So why aren't they telling Canton PD to stand by, stay at the scene, guard the scene? Why aren't they telling them wait for guidance? Why aren't they giving them guidance? Lally asked him about the role of the ME, what role the state police have in making a determination. And his explanation is exactly what I would have expected. And he also said that the police have no role with the ME aside from providing information. And that's about right. And sometimes a trooper will stand in on an autopsy and observe, and that way the doctor and the trooper can share information. And sometimes they call back and forth, but it's about information sharing. That is a reasonable answer. That makes sense. Yet, according to texts between Proctor and his friends, his goal was to actually convince the ME of something. Tully testified he spoke with Chief Berkowitz, and he used that same language that Canton PD was going to take a step back because of the relationships. Tully said that the state police were going to do all of the investigation. And in any case, they technically have exclusive jurisdiction anyway. The state police do. He said that during these conversations with Berkowitz, D.A. Morrissey was also part of this conversation. And Lally asked, is this something that's normal? And the answer that Tully gave was, well, it's not abnormal. And then Lally asked about Proctor's text. And his question and the answer to the question made me understand an objection that had been previously made. When Proctor was on the stand, Jackson was trying to ascertain whether or not he got in trouble for the material that was in the text. And Lally didn't want Jackson to ask that way. So he didn't want to bring out whether or not Proctor had been disciplined or got in trouble with his superiors. So Jackson ended up being limited to asking Proctor if the supervisors who were included in some of these group texts, if any of the supervisors there within those texts pushed back on him, basically, but within the texts. Well, that's not really what Jackson wanted to know, but he was stuck with asking just that because Lally was objecting. And now I understand why. Having to have Proctor as your witness is kind of like carrying around an unstable grenade. If Proctor had said that he got in trouble at work, well, then the jury hears that, right? But Proctor's got this ego. He's not going to want to admit that. And if Proctor says he didn't get in trouble, well, then the defense can argue, look, this culture goes all the way up. This is a big deal. And it's a black mark against the state police as a whole, as an institution. What Tully testified to was that, yes, he was aware of the text. Yes, that he had a discussion, a long discussion, he said, with Proctor, and he told Proctor it was unprofessional, and Tully reported this up his chain of command. And Lally specifically asked, did you admonish him? And Tully said, well, within that conversation, he was admonished. So this is clearly not a formal thing that occurred. It was a verbal admonishment. And we all already know that Proctor still has a job and is still being assigned cases. So by all of his objections, Lally saved himself some problems that he would probably have to clean up, because who knows what the heck Proctor's going to say. So Lally did some damage control and some damage prevention. But that makes me think that Lally knows what he's got. He knows what he's dealing with. Let me put it this way. I suspect he knows that he's a liar on his hands. Tully didn't play it up or play it down. On the stand, Tully sounds like a supervisor, but my concern is that he just was spoken to. So still, what year is it? 1920? Oh, no, it's 2000 something, isn't it? It's still the boys will be boys attitude, is it not? Isn't that what that sounds like? Hey, son, don't do that again. Doesn't look good on us. I don't know what he said, but nothing substantive happened to Proctor in respect to his job in these texts, as far as we know. So why would he stop? Why would he have any introspection? What has he learned? What he's learned is he can do whatever the heck he wants and get away with it. Lally asked Tully if they seize witnesses' phones, if that's something they routinely do. And you know what Lally's after, because you've heard the trial, so I don't need to explain it to you. And Tully gave a typical sort of supervisor reaction, which is, well, when you say seize, I think you're talking about a search warrant. And the bottom line, according to Tully, is, well, yeah, sometimes we do seize witnesses' phones. We don't seize every single one, but yes, we do. And sometimes we just get consent if we can. And if we can't, we get a search warrant and we seize the phone. And I think Lally wanted to hear that, no, we don't do that very often. But that's not the case. And so good on Tully for not kissing Lally's butt on that. He said they got Jen McCabe's and Carrie Roberts' phones. We knew that. And he explained why, and the reasons are obvious. Tully said that he personally went to Canton Police to talk to the chief. And this is interesting because normally he wouldn't be involved. So he went to Canton PD, talked to Berkowitz, and then went to Fairview. And then they introduced the weather reports because in case you forgot, there was snow. It was snowing. He was asked about evidence, and what happens to it when it's taken back to state police. And he described the evidence officers, not everybody has access, all the same stuff that we've heard before. And Lally asked him about what happens if there is no evidence officer available when you bring evidence back. And Tully said it sits in a temporary area, and then when there's an evidence officer available, it's moved to the permanent storage area. And Lally asked him, what, if any, documentation occurs when that's moved? And Tully said there isn't. When it moves from the temporary storage to the permanent storage, there is no documentation when it moves from one to the other. Well, I have a whole lot of questions now. I have a feeling that they're not going to be answered. So when you collect evidence, you're supposed to put on the bag where you got it, what time, who collected it, what's in it, everything you can. You fill out everything. So if that happens and it sits in this temporary area, well, according to Proctor's testimony, he says, I don't know, it would have been, the evidence people would have picked it up the next day, like a day later. Except, none of those envelopes that the lab received are dated January 29th. So it's still a mystery. It's still not clear who the heck laid this stuff out on the butcher paper and all that jazz. Who laid it out? Who folded it all up or whatever they did with it? It was Proctor's name on the envelope that contained the 2 shirts. But what about the taillight pieces? Because they weren't dated January 29th. They were dated much later. So that would mean these evidence guys all came in and just left it there? I don't believe that. What actually happened to the evidence that Proctor says he left there? I'm talking about taillight pieces now. He says he left it there. We don't know. We don't know what happened. But Tully came across well on the stand, and so I think people will believe him. And because of the way he testified on a couple of points, he wasn't just kissing Lally's butt, and because he didn't sit around shifting in his seat saying, I don't know. He wasn't reaching for plausible deniability at every turn. As a matter of fact, he seems to have an attitude of, I make certain decisions. Yep, that would be me. None of this, it's collaborative. It's not me, it's somebody else. He wasn't doing that. And he knows how it works. And of course he should. He's a supervisor. But it's a big contrast to what we've just seen. And, the jury is going to notice that contrast as well. So to see a guy like that is a little more reassuring. And when somebody makes you feel a little reassured, you might not ask question, but I still have questions, and I'm not willing to fill in the blanks so that I can feel better about it. I'm not willing to guess and say, gee, this must be the answer when it's something as important as where evidence was and what was going on with that, especially in light of the allegations being made by the defense. Because feeling comfortable about understanding what happened will not lead to the truth. It's okay to be uncomfortable, to sit in that discomfort and say, I don't know what the answer is. I know that there are outstanding questions, and I'm not going to fill in the blanks in my head so that I can feel better. Tully said that when CERT was doing their search, they're trying to figure out, what are we looking for here? So we know we're looking for a shoe, and we know we're looking for pieces of taillight. So obviously he got the information that there are pieces of taillight missing. But what he didn't know is how much are we looking for? And you can understand that. The front lawn's covered in snow. I mean, are we going to search for hours and hours only to learn we've found everything? So he didn't know how much taillight he was looking for. And I find that interesting. If he knows that Reed has a damaged taillight, I would expect that would mean somebody has seen that damaged taillight and would be able to provide the information. Maybe not directly to Tully, but certainly somebody else, another officer. And Proctor went to Dighton and saw the SUV. So why didn't Tully call Proctor and say, hey, how damaged is it? What are we looking for? Oh, I know the answer to that. Because by the time CERT was searching, Proctor was not indicting anymore. Proctor had already been back at Canton Police Station a good 30 minutes before the CERT team was assembled. Tully testified that it was his decision to take the SUV to Canton Police. He said Canton Police were recused from the entire investigations. None of this, just interviews. He testified about Reed's phone call at 4:45 a.m. This is consistent with what other witnesses have said. She was looking for him at 4:45 a.m. And here's something interesting that came out. Starting from at about 12:33 a.m., Reed made 53 calls to O'Keefe's phone. And I think that might explain something. People were wondering, why is she so panicked at 5 o'clock in the morning? And it's got to make you ask, why is she calling him over and over? 53 calls is a lot. So why is she doing that? Did he tell her, I'm going to text you? I'm going to call you? Did she was obviously trying to get a hold of him for some reason. So if she's calling and he's not answering, whether the explanation is that she's mad, so she keeps calling, or that she starts to get worried, so she keeps calling, I think these 53 calls are important. And they do go to her state of mind at 5 o'clock in the morning. That makes that level of panic make more sense. They showed video from the library at 12:15, and they showed the SUV on the way to Fairview, it appears, at 12:15 a.m. The next video they have from the library is after 5 a.m. So what's missing here, the glaring thing that's missing here, is that there's no video showing Reed coming home at 12:40, 12:50, 1 o'clock. And in the videos at 12:15, notice the ground. I think that image of the ground is much more significant than the image of the SUV. It's grass. John O'Keefe, despite the narratives, the actual evidence shows that John O'Keefe was found on top of snow. So, unless there was a huge amount of snowfall between 12:15 a.m. and 12:45 or 1 a.m., then Karen Reed couldn't have hit him during that time frame. And not only could she not have hit him, he could not have been out there at all. Regardless of what happened to him, he couldn't have been there at that time. The snow tells a story. They show more video from a different location. And again, there's no video of her returning from Fairview. That's the video that everybody needs to see, except it's not there. And in one of the videos, after 5 a.m., I want you to look at this. You can see Reed's rear passenger taillight. Not perfectly clear, so you can't tell from that whether there was a little hole in the clear piece, whether there was a piece missing. It's not a good enough picture for that. But you know what it is showing? A lot of red. This is after she backed into O'Keefe's vehicle. So whether or not she broke that piece of taillight or cracked her taillight in the driveway at John's or sometime after that, it's clear from this video that the whole flippin' thing isn't missing. It's full of red. And if that taillight was destroyed to the extent that we later saw after Proctor had custody and control of her SUV, if it was damaged to that extent, we wouldn't be seeing all this red on this video, in my opinion. I will, however, let you make up your own mind. They show video of her driving around in the morning, and they suggest that as she's driving around at 5:35 a.m., it took too long for her to get to Jen McCabe's. Well, first of all, she wasn't in her right mind. My understanding is that she said to somebody that she was driving around, but here is where Lally wants to go. He gets Tully to say that Reed could have made a turn onto a road, not on the video, and could have then gone in the direction of Fairview Road. So they're implying she could have gone to Fairview before going to Jen McCabe's in the morning. Well, insinuation is not evidence. Theory is not evidence. And they're laying a foundation here. And the idea is to build insinuation upon insinuation. They get into the call detail records. And when he says call detail records, he is referring to the business records. So this isn't an extraction. Here, we would have to get somebody from the phone company on the stand in order to offer this testimony. We would need the custodian of records, but he was allowed to go ahead. So, okay. They talked about cell towers. And Tully talked about dead zones, specifically how a zone can become a dead zone when a tower can't handle the number of devices being used in an area. And he gave an example of going to, I think it was a stadium, and as more people arrive, suddenly his phone, it doesn't function as well because the tower can't handle the influx of all the devices in that area. But I have a question here. How many devices are flooding any area where they want Reed to be at 5 a.m. in a blizzard? And they get into these call details a little more specifically, where the records show which cell tower was used. And they discuss the towers in range and how they can determine only the area where a phone is rather than a specific location. And I have a question. I noticed they're talking about towers and not GPS satellites. The satellites are more accurate. And as I'm listening, I'm thinking, well, they must have a reason for going with the towers and not also, or instead, going with GPS. But they never got into why they went with towers and not GPS. And I don't know if people listening are going to pick up that distinction or wonder about that. It was just odd to me that they didn't explain why they chose to use that instead of the other. And there may be a legitimate reason, but they should have said so. They explain time codes, and time codes are predicated on UTC, and that goes on, and I'm sure the jury's sleeping by now. They switch back to antennas, and the witness says, I'll tell you up front, there can be things that would interfere with a phone using the closest tower. And I think that's an important piece of information because the locations are not precise and not absolute. They introduced maps showing where different towers were, where different locations were, and at different times. So at 12:33 to 12:34, they show this map, and they go through these. At 12:38 a.m., they show that Reed made a call. Between 12:39 and 5:08 a.m., Reed's phone was pinging off the tower closest to Meadows, which is what we would expect. And then they show a bunch of other ones that are consistent with what we've heard. I'm not going to reiterate every detail of all of this because you'll be sleeping. And if you're sleeping, you won't hear the important point. Between 6:03 and 6:57 a.m., Reed's cell phone signal bounced between two antennas, and those antennas were around Fairview. Now, we already know for certain that Reed was at Fairview at this time, and that her cell signals were bouncing between two towers is important to note. They talked about ranging and shows the range within which a device would have to be to make a call, shows the range of the towers. And we know she was driving around then. But Lally was really kind of zeroing in on this. And while I was watching all this, I'm thinking, so what? We know she was driving around there. All of the information that is presented on the maps is consistent with the range that she was in. What is the issue? Well, here's the issue. Lally wants to use a signal bounce to suggest or insinuate that Reed went to Fairview before she went to McCabe's. That's the insinuation. Now, Tully didn't testify to that. He didn't say, oh yes, we know she went to Fairview first. That's not really what he said. He was trying to explain this is the range. Usually, a cell signal bounces off the closest tower. But he had also said sometimes it doesn't. So now it's up to lawyers to interpret the evidence, argue the facts, whichever way that they're going to argue the facts. And Lally, as the prosecutor, should be making this clear to the jury, but he really isn't. On cross-examination, Jackson said, well, you testified, you said you had no probable cause to search 34 Fairview. Did you seek consent? Because they could have got consent. And I've said before in previous videos, Brian Albert could have avoided all kinds of speculation about him by simply saying, hey, why don't you have a look around my house? Go ahead and search. But the police did not seek consent. And Jackson asks, if you apply for a warrant and you don't have enough, so you don't have probable cause, and the judge says, nope, you don't have enough, do you get in trouble or anything? Of course the answer is no. It's not a big deal. You try and get the warrant, and if you can't get it, well, you can't get it. A lot of time, what happens is that they ask for consent before they even try to get a warrant. Because if they get the consent, then they don't have to do the paperwork and go to the judge, and it's a big pain in the butt. So often, they just ask for consent before even trying to get a warrant. So they didn't do that either. And there are no negative consequences to trying to get a warrant and being turned down. So the point is, they didn't even try. Now, why is that? Could it be bias? Could Tully be relying on the information given to him by Proctor? Jackson points out that the police knew that there was a link between the victim and the house at 34 Fairview. And there was a link between the victim and the individuals in that house. The police knew that the victim had arrived at that house. They knew there was a drinking glass found in the yard. And they knew that the victim had been partying with the individuals in the house. And now there's this drinking glass that's broken, found in the yard. Jackson points out drinking glasses are found inside homes. And Tully says, yeah, and bars. And O'Keefe was seen leaving a bar with a glass. But I want to point out that at the time that they found O'Keefe and they found this glass, police had not yet seen the video from the waterfall. This is retroactive explanation here. If you're going to go by what the police were thinking at the time, the rationale at the time, then you can't include the idea that the glass came from a bar because the police had not seen that video yet. So the more logical reasoning would be that the glass came from inside a house. Jackson points out that the police knew, that John O'Keefe was not wearing a winter coat. And while it's true that some people walk around without winter coats, not everybody does. And this night was cold. We've been hearing all through the trial how cold it was. And this goes back to a question I had at the very beginning of the trial, which is, what the heck? This victim's found without a coat. I mean, my first thought was, where was his coat? It wasn't until later that I learned he wasn't wearing a coat. And if he's not wearing a coat, and they know there's a snowstorm coming, how was John O'Keefe expecting to get home? Was Reed supposed to come and pick him up? And if that's the case, that might be another explanation for why she called him 53 times. These 53 phone calls between 12:33 and 5, whatever time it was in the morning. They don't say how far apart they were spaced. They don't say whether they were clustered closer to 12:33 or if there was 1 or 2 calls at 12:33, and maybe the rest of them happened in a cluster at 4 or 3 or 2. We don't know. And if she's up all night making phone calls, being upset or worried, maybe getting more and more worked up, we don't know, then might she be drinking at that point while she's home? Just a thought. So the victim's not wearing a coat. And Jackson asked the obvious. If somebody took off their winter apparel, might they leave it inside the house? Or when you go in a house, you take off your coat, right? Might that winter apparel be inside the house? The absence of a coat on the victim was a neon sign of a clue, or at least a question that needed answering. The obvious place to look would be inside the house, but they didn't look. Why? That question was never answered. Jackson says it's a reasonable assumption that the coat might be inside the house, and Lally objects. And the judge asks the witness, is that a reasonable assumption? And Tully said no. And I've got to admit, this surprised me. I thought he was doing really well on the stand until he said this. And as this back and forth continued, Tully said he still doesn't think it's reasonable. He said, given other information. What information? He didn't lay that out. Jackson moved on to the missing shoe and said, do you think that if somebody was dragging a body, the body could lose a shoe that way? And the witness agreed. Yeah, it's possible. The witness also agreed that one could lose a shoe during a physical altercation. He also agreed that there was a possibility that there was a physical altercation. And here is yet another thing that points to Proctor's tunnel vision. There is a possibility here for how this man ended up where he was with the kind of injuries he had. The explanation also fits the evidence, which at that time was a missing shoe, the injuries, where he was found, the way he was dressed. All of it fits with a physical altercation. Yet that avenue was never investigated. Why? And there has been no logical, evidence-backed reason for that failure to investigate. Now, Tully's on the stand, and this investigating various avenues is Proctor's job. Jackson asked him, could the house be a place where the physical altercation occurred? And Tully said, a physical altercation could occur anywhere. Sometimes you get where there's a physical altercation and the starting point is quite some distance away from where the person ends up. And I talked about this in a previous video too. I did it a little bit sarcastically. I think I said, he could have been chased by a lion or something. The point is, they never checked the area either. They should have been looking at that entire neighborhood, but they didn't. So they didn't look at the obvious, which is the house, nor did they check the area, even though the evidence should have led them there to at least look. If they ruled that out, okay, I could see them looking then in a different direction. But they didn't, because the lead investigator, Proctor, was focused in one direction, and that was away from the Alberts. Jackson asked Tully, are you aware that Brian Higgins said he saw a tall, dark-haired man enter the house? And Tully wasn't aware of this at the time. Well, that's because Brian Higgins wasn't interviewed until February. So why's that? They got into the call records. Jackson was asking about directionality. Tully's maps showed these arcs. It didn't show what side of each cell phone tower is pinging against the phone. And Tully gave, I think, an understandable explanation, which is that the sector information is not shown to the jury. They didn't put all that stuff on the map, like which side of the tower and all that, because the map would get cluttered and then hard to understand. It's just simpler. And Tully agreed that the cell phone could be within a 360-degree radius of the tower. And here's where Jackson goes, and this is good. He pointed to a map, 5 that showed the time, of between 5:20 a.m. and 5:37 a.m. And we're going to get into now what Lally wanted to insinuate here, which is that Reed went to Fairview and then went to Jen McCabe's. So Jackson's zeroing in on this now. So on this map at that time frame, 5:20 to 5:37 a.m., the locations within the range of that tower that her phone pinged off included Fairview, Meadows, and the waterfall, which means Reed could have been anywhere in that whole area at that time for her phone to ping on that tower. And Meadows and the waterfall, so downtown Canton, right? Those locations would make sense. The fact that Fairview is included in the radius doesn't mean that that's where she was. And again, when you're looking at evidence against a person who is presumed innocent, unless the evidence overwhelms that and proves guilt beyond a reasonable doubt, when you assess that evidence, you can't just pick the side you want. You can't pick the interpretation that you like better based on, I don't know, how you feel, or maybe you don't like the accused. If the evidence fits the accused innocence, then that's where you gotta go. You can't decide to ignore everything except what might, maybe, suggest her guilt. It's not supposed to work that way. I'm not saying it doesn't because I've seen it, but it's not supposed to. Then he talks about the map that shows Fairview and Jen McCabe's house. And that cell tower is the same cell tower that also encompasses the Meadows and waterfall. This is the same cell tower that Lally is trying to insinuate, showing some theory, and who the heck knows where this theory came from, but he's trying to make it show that she went to Fairview, when in fact, she went to Jen McCabe's. And the defense puts up their own map, and the map shows that the tower that Reed's cell phone is pinging off of at the time that Lally is insinuating that maybe she went to Fairview first, that tower is closer to Jen McCabe's than it is to Fairview. And it corroborates that Reed went to Jen McCabe's. I'm going to play you a clip.
You also noted that there were two cell towers much closer to 34. There are two cell towers much closer to 34 Fairview than the 57021, correct?
Yes.
And as a matter of fact, you already noted that for the jurors that say at 6 a.m. or 6:05 a.m. and thereafter, when it's clear that Ms. Reed was at 34 Fairview, you found the body of John O'Keefe, that her phone was relaying to those two towers, bouncing back and forth, correct?
Yes. Yes, sir.
Okay, so the two towers closest to 34 Fairview are 57171, correct?
Yes.
And 57286, is that right?
Yes.
And both of those towers picked up Ms. Reed's signal at 12:33 a.m. and again after 6:03 a.m., correct?
You asked me about 12:33, so if it's okay, I'm going to refer back in the exhibit.
Of course.
And that is correct. It hit the 57171.
And then after 6 a.m., it was also picking up, bouncing, I think you said bouncing back and forth between 57171 and 57286.
Yes.
Both of those towers were picking her up.
Yes.
Importantly, though, between 5:20 and 5:37 a.m., neither of those two towers ever picked up her phone or any signal from her phone, correct?
Correct.
There are two other towers closer to Fairview, and those were the towers that bounced off of the accused's phone when she was known to be at Fairview. Both towers picked up her phone signals, but neither tower picked up her phone during the 5:20 a.m. time frame that Lally is trying to make insinuations about. They talked about the length of time of the communication event, that how long that lasted, and the first and last distances that were on the map. And the distance between the first and last communication was 0.15 miles. And that distance was covered in 0.004 seconds. And this is the time that it seemed that the witness thought the device moved from the first arc to the second arc. And what I mean by arcs is the ranges. They go through this whole back and forth with the math and everything else. The math says that Reed would have had to have been traveling 37 miles per second or 2,250 miles per minute or 135,000 miles an hour. And Jackson suggests it's the signal that is being reflected on the map, not necessarily the device. And the witness doesn't really agree with them, so they got into a back and forth. In my opinion, what all this demonstrates is how confusing or even misleading all of this could be to a jury. I'm not saying that the witness is intentionally misleading. I suggest that Lally should be ensuring that the information is elicited and presented to the jury in a way that is not misleading. It is difficult to take technical or expert information and boil it down to make it simple. And it's certainly difficult to do that thoroughly. People work hard for years and years getting an education and then putting all that into practice for years. I mean, you're not going to boil that down into a soundbite so that everybody can understand all of it and all of the nuances. If it was that easy, nobody'd need to go to school for it. So while it would be difficult to do this thoroughly, Lally could ask, does this mean the device traveled between these 2 points in those seconds? But he didn't ask that. They move on to the Sallyport video. Tully said he got a copy of the video from Canton Police Department. And he said recently he asked the current chief at CPD to create another copy of the videos of January 29th to compare that batch with what they already have to make sure they had all of it. But he didn't actually do the comparison. Because you know who had access to that? You know who was in control of all of it? Proctor. Tully was aware that there was a very grainy video among the videos. He said he didn't review the videos closely. And when he got the second batch, he didn't review those closely. He gave them to Trooper Buchanan. Well, we already know that Buchanan gave them to Proctor. Proctor had access to the video. Tully told Trooper Buchanan when the video arrived. Proctor, as case officer, was responsible for those. Tully testified that the original that he had been given, that he saw, was that grainy black one where you can't really see anything. And he didn't know how he got that. He said it would either be Buchanan or Proctor. They moved on to the search. And he agreed that the police were to maintain the integrity of the evidence and everything. There were photos taken at the time. Jackson got into how many pieces of evidence were found. Like you found a red plastic, then a shoe, then clear plastic, then red. And Jackson was challenging him on the number of pieces of plastic. Tully's report in respect to this search wasn't done until February 2022. And as Jackson's challenging him, he shows him this report that he wrote, where the report says he collected a piece of plastic, not 3. And Tully says, yeah, well, my recollection is no different. Jackson also points out that this was at 5:45 p.m. on the 29th that these things were found and challenges him. He says the report reflects that the total number of pieces of plastic found for these envelopes was 3. But yesterday, when you opened the evidence bags, there were 5. And so he gets them to open these evidence bags again. And inside one, on the front of the evidence bag, it says the bag contains 2 pieces of red plastic. Well, inside that bag were 3 pieces of red plastic. Now, one piece was very small, so one could conclude that maybe it got broken while it was in there. But you know, if that's happening, then they need to package it differently. In the next exhibit, he opens a bag and finds 2 clear pieces of plastic. So Jackson asks him, where did the extra 2 pieces of plastic come from? There's an extra piece in each of these bags, right? Why are there extra pieces of plastic? Where'd they come from? And the witness says he thinks the small red piece maybe broke off. And then he said, maybe my report was wrong. I'll take the hit on that. Rely on the bag. It's going to be more accurate than the report. Well, this is a big problem. You've got reports and evidence bags that don't match up. Evidence bags where the notations don't match with what's actually in the bag. And I'm still having a problem with these bags. Jackson moves on to the Ford Edge. An eyewitness reported that he saw a Ford Edge in the early morning hours sitting right in front of the area where John O'Keefe was found. And Jackson wants to know whether or not this Ford Edge was investigated. And the answer was basically they investigated the veracity of the witness. And he says he didn't believe the witness. And he listed reasons why he didn't believe the witness. And I want to note that in the reasons given, such as, well, his statements weren't all the same, and he was colorblind, and he was a distance away, all of this. Nowhere in his reasons does he suggest that this witness was actually lying. And this troubles me because they investigated the reliability of the witness instead of the facts. I do want to point out that in many cases, especially well-publicized cases, police get all kinds of unreliable tips. They get everything from, I saw a shadow, so it must mean something, to, I hate my brother-in-law, so it must have been him, to, do you think my boyfriend could have done it? To, I had visions, so therefore, this is the solution to your case. I'm psychic, trust me. And they have to sift through all of this, prioritize it, and then follow up. And there are some things that they won't follow up on or can't follow up on. But this is not that. This one should have been investigated. It was necessary to investigate this. I know that the Alberts have a Ford Edge, but let's put that aside just for a minute. Let's assume the police don't know that and they're just getting this tip, okay? So it was necessary to track down this Ford Edge, the owner and or the occupants of that Ford Edge. Whoever was there with that vehicle would be able to provide information. And even if a witness didn't see anything, that is still information. They would be able to say they did or did not see a body. They could say whether or not they saw other people or vehicles in the area. They could testify to sights, sounds, smells. They could say whether the lights in the surrounding houses were on or off. They could say whether they saw tire tracks. They could say how many vehicles were in the driveway at Fairview and whether or not those vehicles were snow covered. They could say if they saw footprints in the snow. They could bring up some detail that no one thought to ask about or that no one knew existed. But you have to check. And I note that when Tully was testifying about this tip, he did use the term we. And thus far on the stand, Tully has demonstrated he has no problem taking responsibility for his own actions. So I don't think that his use of we is anything other than the common usage. I don't think it's any kind of game like what you saw with Proctor. I believe he is using we as the collective because it's not I. If it was Tully who made or okayed the final decision, it was based on the information he got from the case officer or his team. And who's the case officer? Proctor. On redirect, Lally went after this again and got Tully to explain again that there were inconsistencies in this witness's statement. But that's besides the point. Witnesses give statements that seem off or they get things muddled up, they get their time frames wrong. It's not the job of the witness to hand it to the police in a nice little tidy package. It's the job of the police to look into this and sort it out. But they didn't. They didn't investigate. On redirect, Lally also gets Tully to say that the evidence found was on the roadway. Well, it doesn't actually matter by this point, because by the point that they find anything, Proctor already had Reed's SUV. And by this point, everything was compromised 6 ways to Sunday. And Lally tried to get Tully to say that the Canton PD cameras are motion activated. But this is not proper. Tully isn't the guy in charge of Canton Police cameras. Lally gets Tully to say that the information that's filled out on the evidence bags is done at the time of collection. And this is key and not in the way I think Lally wanted. And the report is done later. And Lally asks if what's collected in the bags was collected on January 29th. And Tully says yes. And here is the big problem. The bags were dated February. If the notes are made on the bag at the time of collection, then that evidence was not collected on January 29th. But a member of the CERT team did take the witness stand and did say, yes, we found red pieces of plastic on January 29th. If the evidence was collected on the 29th, then where was it until February 10th when it was put into the bag, the evidence bag? Where was the evidence between the 29th and February? And Lally tried to elicit information that would dismiss Jackson's point about Reed's phone traveling 135,000 miles an hour. But Lally is either misdirecting again, or maybe he didn't comprehend part of Jackson's argument here. Part of Jackson's argument was a pushback on Lally's insinuation and Lally's willingness to elicit the information in a manner that would likely mislead the jury and then let that mislead stand. That Lally is now doubling down here is a concern. It suggests to me that going forward, Lally might do the same thing with other expert witnesses. And doing this is unfair to the witness, unfair to the jury, the court, the defendant, the public, and contrary to the proper administration of justice. On recross, Jackson tried again to nail down the information about all this interpretation of the cell phone maps and notations. I have no idea what people thought of this, and I have no idea how the jury is taking this in or interpreting this. If you were on the jury, what would you have thought of all that? In assessing Tully's actions, it's important to keep in mind what he knew or believed at the time. He's relying on his team to tell him the truth. Ever had a supervisor who micromanaged? If you're a supervisor and you don't trust your team, well, there's no point in having a team at all. As for the overall picture of Tully, I do not think this man was intentionally trying to frame anyone. I'm still having a big problem with these evidence bags. But I think Tully trusted his team and came to conclusions based on the information that was given to him. Now, none of that covers off everything else. It doesn't redeem this case. A number of things came out of this testimony and how it was elicited. I'm going to list some of those things. Lally continues to omit and gloss over important facts. Lally seems not to mind if the jury is misled. Lally is trying to convict through insinuation rather than evidence. Proctor has some reason for failing to state how he got Lank's phone number when the answer should have been simple. So that tells me that how he obtained the number was not the regular route, and we still don't have an explanation for why. Knowing that by law, the state police had exclusive jurisdiction, that Proctor got the call from Buchanan at 6:48 a.m. That procedure is to give guidance to local police until state police could get there. What did Proctor do or not do? If you want to be generous to Proctor, the best you could say is that he didn't do what he was supposed to do. One could also say he gave Canton police the okay to leave the scene. Or he could have lied to Canton police and said that the state police were not coming. That would explain why witnesses from Canton police testified they were under the impression that the state police were not coming. And that would explain why Lieutenant Gallagher figured he needed to improvise. When I first heard Gallagher's testimony and saw the leaf blower video, I couldn't immediately make up my mind as to whether that was all out wild with no excuse, or whether it was wild, but that the guy was trying to do what he could with the resources he had. And when I say resources, I include training. He has no forensic training, but he did know that the evidence would be lost, and he recognized he needed to at least try. He also had the sense to have that scene photographed and videotaped. Now, everybody can laugh at the solo cups, but Lieutenant Gallagher's actions foiled or partially foiled what I strongly suspect Proctor was trying to accomplish that morning. Gallagher saved 3 crucial pieces of evidence. 1, the photo of where John had been. The photo was taken right after John was moved and before more snow fell to cover that up. The photo shows that there was snow and a fair amount of it under John. The photo also shows a transfer bloodstain pattern. Now, the EMT called that pooling. The amount of blood on the snow in that location does not fit with a person actively bleeding for a long period of time. The photo shows the glass was underneath John's body and was lodged in snow, not grass. In the leaf blower video, you see blood drops. That bloodstain pattern is different from pooling, different from transfer. Also, the size and location of those drops point away from the suggestion of it being a velocity or spray pattern, meaning he didn't cough those up and they didn't land there as a result of CPR attempts. There are other reasons why they're not from CPR attempts, which I won't go on and on about. Those drops mean the source of that blood was above the ground and fell there. If Gallagher had not done what he did, that critical evidence would have been lost. I strongly suspect that Proctor was counting on the evidence being lost. Also, having Canton PD and everybody else leave the scene would put the scene in the control of Brian Albert, given the exclusive jurisdiction of the state police, along with the recusal of Canton PD. And that Proctor knew this on the 29th. Proctor has no excuse to involve anyone from Canton Police after that, especially Kevin Albert, in any aspect of the investigation except to interview witness officer. And as those Canton police officers were now witnesses for the state police, such interviews should have been conducted as per protocol. That Proctor faced no disciplinary action for his texts, including texts in which he leaked information, says something about the attitudes within the organization that Tully reported this up his chain of command, and Proctor still didn't face any meaningful consequences. And I use the word meaningful here intentionally. This tells you that the organization has some impactful problems that they are not dealing with. They need to take action on the bigger problem here. Not only did the major issues on the chain of custody of evidence not get addressed, it was shown it's even worse than we thought. The Sallyport videos. For state police to ask again for all of the Sallyport videos was a good move. The original set of videos, which, by the way, had already been tampered with, were in Proctor's custody and control. In the second set of videos that they got, well, they ended up in Proctor's custody and control. Proctor's team and his superior officers should be able to trust him. He is the proverbial fox in the henhouse. You might even call him a mole. In the second set of videos, there was additional footage. Now, how interesting that in the second set of videos, there was a clearer video, not black and grainy and impossible to see, and video clearly showing Proctor at the passenger side taillight. Do you think Proctor might have reason to prevent anyone else from seeing that? And interesting how it's that video that gets reversed. So it appears that Proctor is on the driver's side. Interesting how Proctor slipped up and testified that when he reviewed the footage of the not inverted video, he said the timestamp was yellow. He described characteristics of the timestamp that we wouldn't have expected to hear. And for all of this malarkey, heck, never mind malarkey, malfeasance. And malfeasance is still a generous characterization of the physical evidence. Who is the person who had access and control? Proctor. Who is the nexus to everything at 34 Fairview? Brian Albert. Who had influence and control over the narrative and information inside the state police? Proctor. Now, if that's not enough for you, then let's look at who Proctor is. And this is based on his behavior. He's a misogynist. He is controlling. He holds strong prejudices. He doesn't respect rules and norms. He seems to think he's superior. He has no problem telling outright lies, provable ones, including while under oath. He engages in deception. He is practiced at deception. He expects to get away with whatever he does. He does not accept responsibility. He will not allow anyone to hold him accountable. He justifies and minimizes his deplorable, inexcusable behavior. He shows no empathy. He delights in mockery and cruelty. He accepted a bribe. He is vengeful. I could go on, but I'm tired of thinking about this guy. And by the way, this is only what we know. Who knows what else? The murder of a human being, the murder of a police officer is huge. What happened during this investigation and what didn't happen that resulted in this stunning trial is pretty bad. All of it is bad enough, but there's more. There is something much bigger that underlies all of this. We are seeing the tip of an iceberg that a few people are trying real hard to push under the surface. It's going to take expert divers to get to the bottom of it. That's all I have for you for now. Trust your gut. I'll see you in the comments.